This is AM 650's The Law Show with Sterling Fox. Now back to the show.
Welcome back to the program. We're talking with David Hobbs and Ian Girotti from Hobbs Girotti, Vancouver estate litigation lawyers, and we're talking about probate. And Ian, we just talked moments ago about what constitutes a valid will and all of these sorts of things. So let's assume that the process of determining whether or not a will is valid it's been given a thumbs up. We do have a valid will. So now we can take this to probate. What is probate?
Well, I'll take that back a notch.
Okay.
Because you don't have a valid will. You haven't proven that you have a valid will until you achieve probate of that will.
Oh, so that's part of the process.
Right. So,
okay.
So probate, you can think of it as proof of the will. So what you're doing is you're putting an application before the court, which includes the original will, if you have it, attached to an affidavit of the proposed or the named executor in the will, saying, please provide me with a grant of probate which recognizes this as the last valid will, appointing me as executor, and then away we go.
So the probate is sought by the executor? Is that the procedure, David? Is it once you know who the executor is going to be? If you're the executor of someone's estate, you know about it. It's not a surprise generally, or is it?
Well, the way I think of it, Sterling, to try to help the listeners is that it's really there's a question: is the will the last and a valid will of the will maker?
Right.
That's the question. So who gets to decide that question?
Mm-hmm.
The court.
Okay.
The court has the jurisdiction. It pronounces that is a valid will. And so it's really, probate is the process before the court to get that pronouncement, and that's the grant of probate. That's when the court pronounces that that's a valid will.
And what I guess I'm asking is, who approaches the court to get this grant? Is it the executor, or is it the family of the deceased? Is it an attorney? Who does this formal approach?
Normally, the executor. That's part of the administration of a estate, is obtaining the grant of probate. But if the executor doesn't do it, or something happens that frustrates that process, maybe the executor passed away and somebody else has to be appointed,
right,
or whatever, then somebody else. But it is the person or persons who are going to administer that estate. Ultimately, they're the ones that are going to pursue and need the grant of probate, so that they then can administer, because without it they can't administer because they won't be recognized.
Okay. And is this done by is the grant to go forward and execute the will, is that grant given by a judge, Ian, or is it an automatic? Do you apply and just get rubber stamped? How does it work?
Right. So it depends on the nature of the proof that is being sought. So the normal proof that is being sought of the will, the normal probate application that's being sought is what they call proof in common form. And that's an uncontested application to prove a will. If there's a contest about the validity of the will, then you actually have to prove the will in solemn form, and that will involve going before a judge in a courtroom and having a probably contested, almost undoubtedly contested dispute over whether it's a valid will or not.
Yeah, there is a hierarchy in the court system of power of decision making. So the most complex matters, trials and complex contested issues, judges decide those things.
Okay.
And then lesser, more common things, more routine things may be decided by a lower level decision maker, such as a master or a registrar. So in the case of the probate registry, if it's an uncontested probate, straightforward probate, then the registrar and his staff or her staff are going to administer that process, and they're going to issue the grant of probate under their authority. They're not going to hand it up to some judge and say, could you rule on this?
Right.
Because it's not at that level. If it's contested, it's probably going to be dealt with by a judge at some point, hearing evidence and and dealing with the matter.
Ian, I described Hobbs Girotti as Vancouver estate litigation lawyers. You've already presented a case where the will hasn't even been opened or read or executed. There's a fight already. Some parties in this affair are convinced it's the will is, there's something wrong with the will. The court can't possibly approve this and grant probate here. This has been drafted poorly, or there are errors. Do you get called in for these matters this early in a case?
Sure. We certainly can be. And, that would normally be getting a call from someone who may be an executor or a beneficiary in an earlier will.
Oh, who was excluded from the last one?
Or not treated as favorably.
Okay.
It could be a host of potential persons, but usually it's someone who has an interest in the estate, either in the will that's being disputed, or the will, or an earlier will, or on an intestacy.
Okay.
If the will's invalid and there's no earlier will. So, and then there are tools available to that person to halt the probate process.
Okay, until everyone is satisfied that we have something we can agree on, and then we can go forward with the execution of the will.
And
right?
if they can't agree on it, the court makes a ruling on whether there's a valid will, which will it is, whether it's an intestacy.
An executor might come in with the will and say, can you interpret this will for me? I'm not sure what it means. I'm not sure it's telling me what to do.
Now, you guys do a lot of work with executors, don't you? Lay people who have been appointed to look after the affairs of usually a relative or a friend who haven't a clue what the process is about, and they need some legal input.
Sure, and it can be complex, because the executor will say, well, I'm not sure if I'm supposed to read this will this way or that way.
Right.
I'm reading it, but and if I read it this way, Johnny gets everything, and if I read it this way, Susie gets everything.
Right.
And or the executor might say, if I read it this way, I get everything, but if I read it this way, somebody else gets everything, and so on and so forth.
Sure.
And so those kinds of discussions have to do with the interpretation of a will. Maybe there's a mistake in the drafting of the will. So that kind of discussion can take place. Simple probate, there's no issue about the interpretation or drafting of the will. The will is the will, and it's been drafted properly, and it's going to go through a simple probate.
Okay, so far this discussion has assumed one important thing, that a will exists, and it may be disputed, but ultimately we have a document of some kind about which we can argue but eventually resolve the file. What happens when a person dies who does not have a will? Then what?
Well, this is the term intestacy. That's what that's the term a lawyer would use.
And that's what you used that just a moment ago. So you're referring to non-will cases.
Right.
Yeah.
Okay.
So when we talk about administration, wills tell you how to administer the estate.
Yes.
They tell you pay the bills, here's who gets the property, and so on. That's the instruction of the administration of the will.
Right.
Pay my taxes and so on. So the administration is the guidance, the recipe, if you will, is in the will.
Mm-hmm.
But if there's no will, then the recipe is in the Estate Administration Act. It in effect is like a piece of legislation that's a one-time will. It's the garden variety of how that estate's going to be administered. It tells you how the property will be divided depending on who's alive.
So it's a template then that applies equally to every person who dies without a will?
Everybody in British
Interesting.
Columbia,
In BC, right? Of course. Yeah.
They get the result that's set out in the Estate Administration Act, and an administrator has to be appointed, who is the equivalent of an executor had there been a will.
Oh, okay. Now, how does Hobbs Girotti, if at all, Ian, get involved in situations where there is no will, and clearly then there will be, I would expect, several unhappy parties?
Right. So there's, to be clear, Sterling, there's really two ways you get to an intestacy. One is there is no will.
Right.
There just was no will was ever made.
Yeah.
The other way is if there is a will, but that will is not valid for some reason.
Okay.
And there's no earlier will. The effect of an invalid will with no earlier will is you're into an intestacy.
Okay, so that was the probate challenge that you were talking about earlier, when there is a dispute as to whether the will is valid or not, and if it's found to be not valid, then it becomes no will.
Well, It depends if there is an earlier will that is valid.
Oh, gotcha. Okay.
Right? Because if there's an earlier will that's valid, then that will be proven before the court in the probate process.
Okay.
I mean,
Now,
I'll tell you a story that, so say a gentleman has no wife, he has no children, elderly fellow. He makes a will in 2000, we'll pick. And by 2006, 2007, he's becoming incompetent. He has dementia and so on.
Right.
Around 2006, 2007, he makes another will. Somebody meets him and he decides he likes that person and the estate's going to go to that person. Maybe he meets another person later and makes another will. So now he dies. And so you have a 2000 will. He was probably competent way back when.
Right.
Everything was okay.
Right.
His mind was starting to go in 2006, 2007. Maybe he could make a will. Maybe he couldn't.
Right.
And probably for sure in 2009 he was really gone.
Right.
And that will's probably no good. But the most recent and valid will is the 2009 will, and you have to work backwards basically to get to wherever you get.
Ah.
Because the validity of the most recent will have to be dealt with. That would lead you back to the 2007 will. The validity of that will would have to be dealt with. And if it was invalid, you'd be back to the 2000 will.
This sounds like the sort of case that you fellas have taken on more than a few times. How does it usually work out? Do the courts usually recognize the competency issues and allow the will that by agreement and by evidence was written and drafted while the individual was in full charge of his or her faculties? Do the courts eventually go, well, yes, that's the last one where we know that the individual was fully in command of his or her abilities, and that's the one that should stand? Or do you have to convince the court vigorously to accept that premise?
Well, the interesting thing about capacity to make a will is that it's a pretty low threshold, Sterling, and I think I think that's a decision that's been taken over many cases over many generations, and I like to think of it as the courts recognizing that they want older people to be able to make a will to have their estate distributed as they like, so, as long as they have a certain low level of threshold to make a will. So
Okay.
they don't have to have their complete faculties.
Oh.
You know, for example, if they have Alzheimer's and they come in and out of the effects of that,
Right.
at times they may have the lucidity
Sure,
or the threshold capacity to make a will. So I would say that if a will is challenged on the basis of competency, they can be quite complex, involved cases involving medical evidence. But at the end of the day, capacity is a legal test.
Right.
And so it definitely involves the person who took the will instructions and created the will, a notary or a lawyer.
Okay, now we need to take a break, but this has just provoked a sort of a curiosity question, David. Would there be any benefit to an individual being videotaped while in the notary or lawyer's office at the drafting of the will as some kind of further evidence as to the competency of the individual at the time that will was drafted? Might that be a little extra chip at some point down the road?
I think definitely it's a great idea. No, I've never had anyone ask me that question, but it's simply a piece of evidence and allows you to visually observe what was occurring. Normally the evidence is the notes of the lawyer or notary as to the questions asked and the answers given, and you're looking at the notes that were
Sure,
made
of course. Right.
But you can imagine that a video where you could see the poor drooling confused person versus the with it on the ball person, the visual evidence would obviously be useful.
Interesting stuff. Well, it's the digital era. It's not very expensive to do this anymore, and I'm surprised that there's not a little bit more of that going on. And I'm also glad you hadn't heard that question before. You just made my day, David Hobbs. This is The Law Show on AM 650 with Ian Girotti and David Hobbs, Hobbs Girotti in Vancouver, and we're back with lots more right after this.
There's more of the show still ahead. This is AM 650's The Law Show.